People. The appeal in the name of Dairy UK and Oatly AB.
Yes, Mr. Mears.
May it please you, my lord and my lords. I appear for the appellant and the applicant for a declaration of invalidity in this matter, Dairy UK, who are the Trade Association of UK Dairies. My learned friend, Mr. Edinburgh, King's Counsel, appears for the respondent and registered proprietor, Oatly AB.
Yes, well, I can tell you that we have read the hearing officer's decision, the judge's judgment, the skeleton arguments, and we have looked at, but almost certainly not mastered, the regulation and tofu term.
My lord, I'm obliged. As your lordships will be understand, the dispute concerns the registration by Oatly of its trademark 3445440 in relation, in respect to the word mark post-milk generation for various oat-based and non-dairy-based products that are intended as substitutes for products in classes 29, 30 and 32 of the register. The mark is at tab 7 of the bundle. The mark is also registered for T-shirts in class 25, but there's no objection to it remaining on the register in that regard. That was, although the original application for a declaration of invalidity sought to challenge even that aspect of registration, that's not pursued. My lord, the issue on the appeal concerns the correct interpretation of Article 78 of Regulation number 1308/2013 and its associated Annex VII. It's been referred to in the skeletons as the regulation, in distinction to the earlier version of it, which is referred to in the judgments below as the CMO regulation. It is the most recent version, and it is retained as assimilated law, the most recent version of the Common Market Organisation regulation, which governs, amongst other things, the marketing of agricultural products in the UK, and indeed in the same form throughout the European Union. My client's case is that the use of the mark post-milk generation in respect of non-dairy agricultural products for which it's registered is prohibited by Article 78 of that regulation, and in consequence it's liable to be declared invalid under Section 3(4) and Section 47(1) of the Trademarks Act 1994. Now, Lords, the 1994 Act aspects of this appeal give rise to no issues, but if it would be helpful, I can show you where that is in the authorities. It's at tab 7.
And the provisions are set out in the hearing officer's decision.
My lord, they are. It's my lord, but I can take the panel to it, or we can take it through. It's common ground that the prohibition under section 3(4) is absolute. It's not one of those prohibitions that can be saved by acquired distinctive character, and the prohibition is that a trademark shall not be registered if or to the extent that its use is prohibited in the United Kingdom by any enactment or rule of law other than law relating to trademarks. So that's at tab 7, page 165 of the bundle for your note. The central issue on this appeal is the correct interpretation of the term designation within Article 78 of the regulation. Now, I'll come to Article 78 at some length and the annexes and the other regulations and directives that are referred to within it, but just to summarise, within Article 78, designation is one of a trio of terms whose use are controlled in the context of marketing. And that trio is definitions, designations, and sales descriptions. And the particular issue on this appeal is whether a trademark, or part of a trademark registration, can amount to a designation for the purposes of Article 78. Now, without giving any spoilers, Dairy's position, and that of the hearing officer at first instance, is that a mark can amount to such a designation, and in consequence the use of the term milk, which is a controlled term under the provisions of the regulation, as part of the mark amounts to use of a designation prohibited by Article 78. My learned friend disagrees, and his contention, which found favour on appeal with Mr. Justice Richard Smith, is that a trademark can never be a designation for the purpose of the regulation. A designation is a generic name, he says, for a product. And although my learned friend's position is advanced in the context of the present fact, it's a general point. Now, just pausing, that would have the slightly extraordinary consequence of excluding from control under Article 78, which is an article concerning the use of designations, sales descriptions and definitions in marketing, excluding from the ambit of that provision trademarks, because they are not designations, he says, and in consequence what is likely to be the most prominent feature on any piece of packaging, which is the brand, would be excluded from this piece of consumer protection regulation.
Yeah, so you say on the Oatly construction, there would be nothing to stop them registering and using Oatly milk.
My lord, yes. So this is not, obviously it's not what they're doing now, but this is, there was when we come to the appellant, the appeal judge's decision, he analyses how the difference between the use as a mark and use as what he calls a designation, so the sales name. And so you could have Oatly milk as your brand, and as long as you're not using it as a name of the product, as he says, this generic name, because it's a brand, if you use that in relation to something that is oat milk, that would be absolutely fine. And we say it's not supported by the wording of the regulation, and you would need some pretty strong indication.
The other question is where you draw the line between a generic description and a trademark. Anyway, let's take, and this is not my example, it's my Lord Justice Snowden's example, the designation champagne, which is of course a designation of origin, geographical origin, but it's also a collective trademark.
My lord, yes. My lord, yes. And so our construction is that a designation is a term of some breadth. It covers, it's not a term defined by the regulation, though it was in fact defined in an earlier version of the regulation, and that has led, I think, to the judge going straight below. But it's a broad term which, in relation to a product, is liable to provide some information about it. I'm trying not to use the word designated. Like this. So it is a term that indicates information about a product. That could be the name of the product, as my learned friend says. It could be bread for bread. It could be champagne for champagne, might be the name. But it could also be some information about the nature of the product, whether it's frozen, fresh, organic, genetically modified. That would be a designation of some sort. It could be its origin.
Well, that's actually champagne.
My lord, yes. Sorry, pointing is rude, but my lord, yes.
Sorry.
But origin covers both geographical origin, which might be it might be a PDO, a protected designation of origin, which is a designation, and that is specifically protected. And sure as eggs is eggs. I'm pretty sure champagne is a PDO amongst many of the other ways in which it's protected by the great houses. But that would also include a designation not of geographical origin, but of trade origin. It covers the entire panel of ways of referring to properties of a product, and it would be, without some clear indication, be wrong to exclude from that what would be the paramount way of indicating something about the origin of the product, which might be its brand. So we say the term is broad. It encompasses within it more specific forms of designations, which may have specific titles, such as the name of a generic, the generic name of a product, which in the regulation is what's called a sales description. So that would be a designation, but it is also a sales description. But we say that it also encompasses the brand, unregistered brand, trade name. And so all of the issues that arise from attempting to draw the line, to define the ambit of whether a brand is generic enough or not generic, and is it a trade description, a designation, those all fall away if one takes what we say is the correct approach, which is a designation is a broad and general term for the indication of property of a product. Now, the appeal requires consideration of the legal framework of the regulation, and how the terms designation, sales description, and name have been used in the various that regulation and related aspects of legislation that are referred to. My lords, the regulation is now assimilated law. In the original authorities bundle, we have the EU materials. There's a supplementary bundle, for what it is worth, with some of the key provisions in the form now in force in the UK. There's no material difference between them, save in two regards. One is their scope.
Sorry. Can you just pause for 1 second? I think we just had a...
Bundle next, Joe.
We've had a bit of a swap of materials. Right. Because I marked mine up. So, right, probably in the wrong place, but right.
So to where I was come from is I can show you, and on occasion, if relevant, I can take you to the specific provisions that are now in force, as they have been amended to excise references to the European Union, so instead they refer to the UK.
But don't forget Northern Ireland, because the regulation still applies directly in Northern Ireland, and that's not by any means incidental, because of course, if the trademark is invalid in Northern Ireland, it's invalid throughout the UK.
My lord, absolutely. But the changes that have been made, which vary, other than in Northern Ireland, so in England, Scotland and Wales, they vary the geographical scope of various aspects, and the variation to the identity of the entity who can make further regulations, who can vary things. Those have changed, so
Right,
it's
okay.
changed for the, but otherwise there's nothing within it.
Well, that leads us to the status of the Commission decision. What's the status of that?
So, my Lord, the Commission decision was in relation to an earlier version of the CMO regulation. As explained in Tofu Town, it applies to and provides a list in relation to the products that are within the first part of the proviso to point 5 in Annex 7.
Well, you say the first part of the proviso. Why is it not both parts?
Well, my Lord,
We're going to need to look at that later, but let's deal with the question of its status first.
my Lord, yes. That applies, in relation, it's the list that has been determined by the Commission under the power that they had to make such a list. No further list has been made by this jurisdiction's legislature.
Does that list still apply to
So
this
it still applies
jurisdiction?
here. Still applies here. In relation to, and on its face, and how it comes in, it still applies, and in my submission, it applies not only in relation to the English terms that are in there, but there are also, as one sees, there are French terms and German terms and other things.
Yeah, I mean, I don't think it matters for the reason that I just gave, because
The regulation.
the regulation applies directly in Northern Ireland, and therefore the Commission decision must apply directly in Northern Ireland. But nevertheless, for completeness, are you able to answer this question? So far as Great Britain is concerned, is the Commission decision part of assimilated law?
My Lord, that is my understanding, but I will check to see whether it's because I'm aware that there are lists and matters that have been excluded and are not, and so it's perhaps bold to say it's so without going and checking. But were it not, that would leave a surprising lacuna and inconsistency in terms of the nomenclature that can be used in relation to Annex 7 matters. I'm not saying that it's impossible it's happened. Vast range of things have happened in things, but it strikes me as unlikely.
Yeah.
So, my Lord, before we delve in to the regulation, may I give you a very brief route map to my submissions? First, I'll give you an extremely brief summary of the dispute to date, just the chronology of
I
where we
don't think
are.
we need to do
Then I won't.
I think we've got that.
My Lord,
clearly enough.
then I shall. The only point that I would flag, rather than going into it in detail, is that at first, on the application for declaration of invalidity, there was a challenge on the basis that the mark was deceptive.
Yeah, and that failed.
That failed, and it's not challenged. And the hearing officer rightly recorded that she's applying a different test to those matters.
Yeah.
So then we'll start the bulk of my submissions and go through the legal provisions and show you how the scheme works.
When you say the mark, when you say the mark is not deceptive, can you just explain or just unpack for me what deception is not being practiced?
Right. So, my Lord, what deception is not being practiced? There is a challenge to the validity of the mark. It's an absolute ground for refusal of registration that a mark is of such a nature as to deceive the public.
Yep.
And there is a particular test that is required to show that it is liable to deceive. And the mark itself, post-milk generation, the hearing officer formed the view that it would be, the average consumer would understand it as an ironic reference, when looked at as a whole, to the nature of the consumer. It's for a generation that is, as I understand what she said, dealing with matters after milk, so it's beyond milk.
If you stick post-milk generation on a T-shirt and you stick it on a person, it's descriptive of the thing inside the T-shirt.
My Lord, yes.
That's pretty obvious, I think, irrespective of whether you take the view it's agricultural product or not.
My Lord, yes.
If you stick the word post-milk generation on a carton, are you accepting that a member of the public would not be confused into thinking that there was milk in the carton?
My lord, I'm accepting that it's not, that of itself is not, because we don't challenge that finding of the hearing officer, so I can't. I'm accepting that post-milk generation is not inherently deceptive, so it would, but what I do say is it does not clearly indicate in that it's an ironic reference. It doesn't clearly indicate any property of the product to which it's applied. So there's two ways. One can be, if there's a fog, in terms of the meaning of a term, the fog is enough to defeat a challenge on deceptiveness. But the fog is not sufficient to amount to something that clearly designates a characteristic of the product. So that's where we land on is it deceptive, is it not deceptive?
We'll have to come back to this a little bit.
My lord,
yeah, okay.
my lord, yes. There is a in order to be deceptive, it's a relatively a high hurdle, and it is a different test to the second limb of the proviso under point 5 in part 3 of Annex VII of the regulation, which is refers to the list of products and all products which the use of the designation to clearly designate a doing this from memory, but a characteristic of the product. And so we say that post-milk generation, whatever the hearing officer may have held about it being an ironic reference to something suitable for the post-milk generation, that doesn't clearly indicate.
And this arises on the respondent's notice?
My lord, yes. My lord, yes. So, my starting point will be to go through...
Just out of, and perhaps I'll just put the question out so you can think about it. You don't need an answer now. Just out of interest, if it was post-milk generation, would that make a difference?
My lord...
the only reason I asked that is because that's the explanation that the hearing officer gave.
Yes. But, well, my lord...
Anyway, I don't, as I said, I didn't want an answer straight away, and it may not matter, but it just did occur to me that if one is talking about the test of clarity,
Well, my lord...
the hyphen might conceivably make a difference.
Well, my lord, it might, because absent a hyphen, one might look at it and say, well, if one's talking about something post-milk generation, one could refer to as a cow who has just been milked as being post-milk generation. There are all manner of different possible meanings for this as they go through, and what the hearing officer held was sufficient to defeat an attack of deceptiveness, but it's not, in any sense, on any basis, we say, a finding that the use of the term of which we complain clearly designates a property.
No, I understand your
So that's the point. And so, my lord, the hyphen is, but if it hangs on a hyphen, my lord, we say that's far too close.
Well, they don't have a hyphen, so...
Well, my lord, so then there will be nothing for it to hang on.
No. Anyway, I just wanted to put it out there now, so if it was of any relevance at all, people could think about it.
My lord, I shall. But before I leave it, this danger of an interesting point raised. It is absolutely plain from the hearing officer's decision that she was of the view that the second part of the proviso did not apply, so they didn't escape under this, and she had well in mind her own decision in relation to the ironic understanding of post-milk generation and the fact that the mark was not, she held was not deceptive. So, my lord, it would be odd in the light of that, the hearing officer's view, to say, well, nonetheless, it means that it must be a clear designation. That's not what she held, and that so we rely on her finding in that regard. So, back to my route map. At the start of my submission, I'll go through the legal provisions and then take you through the Tofu Town Authority. Then I'll go through the judgments of the IPO and that of Mr. Justice Richard Smith to show you where we say he fell into error and why we should succeed on the appeal. I'll then address my fallback position on ground 2 of our appeal, which is notional and fair use and milk within that. So if I'm wrong on the first ground and a designation is held to be mutually exclusive to a trademark, we say why the mark is still objectionable, and I'll address my learned friend's respondent's notice point, and indeed my Lord Snowden's questions, Lord Justice Snowden's questions, as they arise in the context. So the starting point is the legislation, and that is tab 6 of the authorities bundle is what we call the regulation, so EU 1308/2013. So page 117 of the bundle is the start. My lords, it's a point I've made already, but this is not, this regulation is, and it's only extracts of it that are here, is not solely concerned with marketing. This is the CMO regulation to do with the organisation of the agricultural markets, and it governs what can be sold in terms of products, appropriate agricultural products and the properties they may have, as well as how they are described. You can see that, just for example, by recital 2, this regulation should contain all the basic elements of the common organisation of the markets in agricultural products. It is of very broad scope, but the aspects of which with which we are concerned are the marketing restrictions in relation to agricultural products, and they are founded in consumer protection. If I can just, as we go through, if I can show you the relevant recitals. On page 123, there are recitals 64 and 65, which address marketing standards. At 64, it says the application of standards for the marketing of agricultural products can contribute to improving economic conditions for the production and marketing and quality of such products. The application of such standards is therefore in the interest of producers, traders and consumers. And then at 65, following communication with the Commission on Agricultural Product Quality Policy and subsequent debates, it is appropriate to maintain marketing standards by sectors or products in order to take into account the expectations of consumers and to contribute to the improvement of the economic conditions for the production and marketing of agricultural products of their quality. So it's founded in consumer protection, the marketing standards, both in terms of what can be sold and how it can be described. And we see then at recital 76 on the next page, this is the recital specifically concerning Article 78. For certain sectors and products, this is recital 76, definitions, designations and sales descriptions are important elements for determining the conditions of competition. Therefore, it is appropriate to lay down definitions, designations and sales descriptions for those sectors and or products which should only be used in the Union for the marketing of products which comply with the corresponding requirements. So that, again, it defined these terms in order to maintain conditions for competition. And again, it would be, there's no hint within there of some distinction to be drawn between brands, trademarks, or other kinds of designations. So the actual rules themselves are found, they start at page 139. Chapter 1, rules concerning marketing. Section 1, marketing standards, and Article 73. What these do then?
Yeah, well, we're not concerned with marketing standards here.
We're concerned, but it's not just what can be sold, what we're concerned with, which is where Article 78 comes in,
Yeah.
is what you can say about what's being sold.
Yeah.
And so Article 78 we can skip on to then, on page 141. The heading is definitions, designations and sales descriptions, so 3 separate terms for certain sectors of products.
Just out of interest, why doesn't marketing standards apply to dairy products?
It just doesn't.
I know it doesn't. Sorry.
When you look at Article 75,
I know it
dairy
doesn't.
products
That was
are-
the question is why. Does anybody?
It is an oddity, but when we get to
But it's not just, I mean, you could ask the same question about beef and veal. It's the same scenario.
it also may apply to one or more. My lord, it is peculiar, but when one comes to 78, the standard one is, in addition, where relevant to the applicable marketing standards, the definitions, designations and sales descriptions provided for in Annex 7 shall apply to the following sectors of products. So there we have beef and veal and milk products. And within those provisions within Annex 7, there are definitions not just about how matters can be described, but also what they are. So you're only allowed to sell certain matters. So it does. So these the standards do come in via Annex 7 in this particular thing. So Annex 7, although we're concerned with it in terms of what you can say about products, they do contain quite exhaustive provisions about nature of certain products that can be sold.
Now, we are, of course, looking at the English language version of the regulation.
My lord, yes.
Has anybody looked at any of the other language versions to see if they assist?
My lord, I have not. My learned friend, I think, looked at something in Spanish. I see in your.
My lord, only with respect to the proviso in one of the annexes did I look at the Spanish, and not the other languages, because I have no ability to read those other languages.
Yeah, but I mean, if you're going to do the exercise, you have to look at
Yes,
more
no,
than
no,
one
no.
other.
No, I realise that.
You need a selection.
Yeah. But the Spanish one in that particular case was unambiguous, and therefore I stopped at that. But I accept your point, my lord. But there's been no thorough trawl through the other languages.
Well, that's not surprising because it's not an easy task.
No.
Thank you.
And to be fair to my learned friend, his analysis in relation to the proviso was to do with whether the Commission regulation applies to the first or second limb or both of them. I think that's where it's not really
decision.
the designation, the decision. My lord, yes, the decision. We say the position is clear on the English, but we haven't done the deep dive in relation to other languages.
Thank you.
So, 78.1 sets out, in addition, where relevant, the applicable marketing standards, definitions, designations and sales descriptions provided for in Annex 7 shall apply to the following sectors. Milk is within there. And then 78.2, the definitions, designations or sales descriptions, again the use of the 3 terms, provided for in Annex 7 may be used in the Union only for the marketing of a product which conforms to the corresponding requirements laid down in the Annex. So that's the provision that controls the use of definitions, designations and sales descriptions in relation to agricultural products, and limits, we say, the use of the designation milk.
And does that actually mean that the definitions, designations or sales descriptions provided for in Annex 7 may be used in the Union for the marketing of a product only if they conform to the corresponding requirements laid down in the Annex?
My lord,
I mean, because the definitions, designations or sales descriptions presumably might be used for some other reason. The only, presumably, it's saying you can't use them for marketing unless you conform to the corresponding.
my lord, yes. It's
Is that right?
only for the marketing. I don't think it goes beyond and controls their use in well, the extent to which it goes beyond. It's
I just assumed it means you can only use definitions, designations, or sales descriptions for marketing if you conform to the annex.
my lord, yes.
It's just the word "only" is in just an ambiguous place in the
Yes.
English,
Yes, only for the marketing of a product
which conforms.
which conforms.
So, but it's not saying you can't use definitions, designations, or sales descriptions for some other purpose.
Well, if it's not for marketing, it's not saying you may only use them for the purposes of marketing. But if you're marketing,
Then you must.
that's the
conform.
only marketing.
Yeah, that's
must
right.
be
So
influenced. So that's
as I thought. Yeah. Okay.
so. And then it's not so under 78 3, just showing that this provides that the Commission shall be empowered to adopt delegated acts in accordance with Article 227 concerning the modifications, derogations or exemptions to the definitions and sales descriptions provided for in Annex 7. And those delegated acts should be strictly limited to demonstrated needs resulting from evolving consumer demand, technical progress, or the need for product innovation. So there's the potential for changes to be made to this by the Commission. In the equivalent UK legislation, those changes can be made by the Secretary of State.
But not to change the designations.
Well, modifications, derogations, exemptions, definitions, and sales descriptions.
Is that right?
My lord,
So your trio is now a duo.
it is a duo, but given my, to be fair, on my construction, those two are those designations. So you can change designations insofar as they're those two, and indeed the annex really addresses those points.
So what do? We read the word designations into sub 3.
Well, we could look at this point. It might be worth looking at what the
Does it matter?
My lord, I'm not sure it does, but when questions arise, designations, certainly you read in designations insofar as, those are designations, so it would be, I think it would be bold to say that...
Yes, but on your case, it's where it's not a sales description that it matters.
Yes.
Yeah.
Yes.
So, shall we go on to the
Yes,
next?
let's go on. So, at 143 is where Annex 7 appears. And it's headed Definitions, Designations and Sales Description of Products referred to in Article 78. And then the definition at the top of page 143, for the purposes of this annex, so all parts of this annex, the sales description means the name under which a foodstuff is sold within the meaning of Article 5.1 of Directive 2013, or the name of the food within the meaning of Article 17 of Regulation 1169. 2011. So there is a definition of sales description as meaning the name. We say this means that designation therefore cannot mean the generic name under which a foodstuff is sold, or more point, cannot be limited to that, in that you have three separate terms: definitions, designations, and sales description. And sales description is the one that is defined as limited to being the name. And it would be an extraordinarily strained construction to then say that means that designations can only mean the name. Now, why that is relevant is because in an earlier form of the regulation, so if you keep your finger in that tab and go to tab 2, this is the previous version of the single CMO regulation. Let me show you the equivalent provisions. Article 114 is at page 28, which it brings in marketing standards for milk and milk products specifically. And it's not in identical terms to Article 78 at all. Foodstuffs intended, Article 1141, foodstuffs intended for human consumption may be marketed as milk and milk products only if they comply with the definitions and designations laid down in Annex 12. And so there, that's dealing with marketing standards for milk products, milk and milk products alone. It's not addressing a broader reference to other agricultural products at all. And then within that annex, which is at the next page in this extract of 29, the definitions that are given are definitions and designations in respect of milk and milk products, definitions for the purposes of this annex, marketing, it defines marketing as holding or display and so on, and then designation means the name used at all stages of marketing. So that definition, which the judge on appeal took into his account and found, gave some weight to, is different and is not contained within Annex 7. And that, as we come to his judgment, in my submission, that's really the root of his error, and how he found himself in a position where he was saying a designation, accepting the submission that a designation is in fact a generic noun. Of course, we say that a designation can be a generic name, it's just not so limited. It's far broader. Now, the other two, so back to page 143 in Annex 7 of the regulation. Within that definition of sales description, there are references to the name under which a foodstuff is sold within the meaning of Article 5.1 and Article 17 of those two provisions. If we look at those, tab 3.
Sorry, I just lost you temporarily. You went back to one.
Sorry, I went back to 143, to
Yeah.
the definition of sales description.
Yep.
And that is defined as the name under which a foodstuff is sold within the meaning of Article 5.1 of Directive 2013,
Yep.
or the name of the food within the meaning of Article 17. And these are provisions which, again, the learned judge gave some weight to, so it's worth looking at them now. So tab 3 is the directive. Again, on page 31, just looking at recital 6, the prime consideration for any rules on the labelling of foodstuffs should be the need to inform and protect the consumer. This is all about consumer protection. And this directive concerns labelling and presentation and advertising of foodstuffs. Article 3 says, in accordance with Articles 4 to 17, subject to the exceptions contained therein, indication of the following particulars alone shall be compulsory on the labelling of foodstuffs. So this is setting out the list of things that one must put on food labels. And we would say that each of these things would amount to a designation. If you're providing information as to that, these matters would all be designations and contain designations. But the first one is the name under which the product is sold. Second is the list of ingredients. Article 5 addresses the name, and this is the point that was referred to on that in Annex 7. Article 5, 1, the name under which a foodstuff is sold shall be the name provided for in the community provisions applicable to it.
Sorry, can I just go back? Did you say that everything in Article 3 is a designation?
Well, my lord, if one puts those in our submission of what a designation is, those matters, information as to what some property of the product or things that was done, we would say if you put that on a label, each of those would be a designation. Designation is broad enough to cover that. They're not described as designations. It's a submission. It's not a point that finds support.
And in Article 5, the key point is paragraph 2. No trademark.
Yes, in Article 5, well, having defined the different ways in which a name can be used, so it's the name is the name provided for in the community provisions. In the absence of those provisions, then it's the name provided for in the law of the member state. And then there are provisions under 1B and 1C in relation to where sales names in the member state of production can or cannot be used in the member state of sale, member state of marketing. And if one looks at C, just before we get on to 2, in exceptional cases, the sales name of the member state of production shall not be used in the member state of marketing when the foodstuff which it designates is so different as regards its composition or manufacture from the foodstuff known under that name in the provisions of point B. Sorry, that the provisions of point B are not sufficient to ensure the member state of marketing correct information for consumers. So that is, B allows for sort of disambiguation by adding further information. If designation means the name under which a matter is sold, and only that, then it's peculiar to say that you have a sales name which designates something else and you need to use some other term for it. So we say this is all, it's very strange to look at designations being limited only to the particular sales name. But 2 is the important point, my Lord, or Justice Arnold is correct. No trademark, brand name or fancy name may be substituted for the name under which a product is sold. My Lord, so that is in the context of mandatory provisions for marketing, where one has to put down the name as defined at some length under Article 5.1, and it is entirely sensible, if I may say, for there to be a provision saying you cannot substitute a trademark, brand name or fancy name for the name under which the product is sold. But that, to go from that and then say this means that a designation cannot be, as a matter of law under Article 78, a designation cannot be the trademark, brand name or fancy name, or that those matters are not designations, it just goes far too far. This is a requirement that one cannot substitute a trademark or product name, sorry, brand name or fancy name for the required sales name of the product. It doesn't extend further, we say, to mean that designation should be read as excluding those matters. And similar provisions are in the other.
We don't get anything more out of those, do we?
Well, there's only one thing. There's a point in terms of a list of ingredients where there's a reference to a requirement that if something is frozen, it be designated. If it had the designation frozen, which we say again supports our approach, but it's only it's.
All right, where do we find that?
So that is so the regulations at tab 5. And the relevant provisions are at Article 17, dealing with the name of the food. So this is on page 83, sorry. So the name of the food should be its legal name. In the absence of such a name, the name of the food should be its customary name. If there's no customary name, the customary name is not used, a descriptive name should be provided. And then at 5, specific provisions on the name of the food and the particulars that shall accompany it are laid down in Annex 6. And then within Annex 6, which is on page 101, So the name of the food and specific accompanying particulars. Part A, mandatory particulars accompanying the name of the food. A2, in the case of foods that have been frozen before sale and which are sold defrosted, the name of the food shall be accompanied by the designation defrosted. Sorry, I said frozen, in fact, it's defrosted.
Sorry, I have lost your page reference.
Sorry, 101, page 101 at the bottom right.
Yep.
So we say, again, this is entirely consistent with designation having a broad meaning that covers information relating to the product. But my lord, there's nothing further from that. And we say it's all a bit of a red herring in terms of the name of the food, because that provision relates to sales descriptions, not to the broader designations when we're in Annex 7. So page 143, if we go back to Annex 7, we can move on to the meat. Just to orientate you with this. So Annex 7 is broken into a large number of different parts relating to different sectors and different products. Part 1 is meat of bovine animals. Part 2 relates to grapevine products, and it's at page 151 that we get to milk and milk products. There's a very significant set of definitions for grape and grapevine products as to what one can, the definitions of various product terms. But it's not relevant to us here. Part 3, milk and milk products, page 151. So the first 3 points under Part 3 define products and terms that can be used, including names that can be used, and then 5 and 6 are where those 1, 2, and 3 are permissive. They're saying these may be used, well, they do say in places they should be reserved exclusively, and then 5 and 6 are the points that address how marking should not take place. But looking at them in turn, point 1, milk. So this is a definition. We say milk means exclusively the normal mammary secretion obtained from one or more milkings without either addition thereto or extraction therefrom. However, the term milk may be used. So you've got a definition and then how the term may be used. A, for milk treated without altering its composition. And then B, in association with a word or words to designate the type, grade, origin, or intended use of such milk so as to describe the physical treatment or the modification in composition to which it's been subjected, provided the modification is restricted to an addition or withdrawal of natural milk constituents.
So that entitles one to describe something as being semi-skimmed milk,
My lord, yes.
for example.
My lord, yes. Skimmed, semi-skimmed.
Would it entitle you to describe something as being milk-free?
My lord, in my submission, milk-free, because this is not a milk. If it's milk-free, it won't be a milk product. But milk-free is permitted under, we say, the second part of the proviso to 5. Now, my lord, I know this is why in my submission, although it would be helpful to me to say there's an exhaustive list under the regulation of things that fall within the proviso to 5, in order to be able to describe something as milk-free, in my submission that comes in under the proviso to second limb of the proviso to 5. So, point 1, milk. And
So you'd say that, we'll come back to it. You say that it's a designation clearly used to describe a characteristic quality of the product.
yes, because milk-free.
That's what you mean the second. Yeah, okay.
Yes. But here in 1b, in associating with word or words to designate the type, again, this is designation not used as a name. I mean, if you designate it to designation, this is all consistent with my construction of designation.
So if you put coffee milk, i.e. milk for use in coffee.
So, my lord, unless that's within one of the defined terms, coffee milk would not, we say. I mean, I think that's...
Well, you're apparently allowed to use milk in association with a word to designate the type, grade, origin. So type, it could be, it's been indicated, semi-skimmed, or origin could be Cornish milk, presumably.
Jersey milk.
Jersey milk. And the intended use of milk. Now that, you know, I mean...
My lord, perhaps. My lord, then coffee milk.
Barista milk.
My lord, perhaps. So, intended use. Yes, on that wording, that would be permissible. So coffee milk. I mean, the coffee is a bit tricky.
Okay. Smoothie milk.
Smooth. But again, yes. I mean, you might say it should be. I suppose the intended use of such milk. My lord, provided that the modification is restricted. Oh no, that's...
Well, or to, you see, I mean...
And or the intended use. My lord, yes. It's...
The problem with all of these examples is they send you off down different rabbit holes, because the other problem with coffee milk is it might be understood as meaning coffee flavoured milk.
My lord, yes.
Okay, it wasn't a particularly good example.
No.
But trying to indicate it's a milk, the constitution of, or the composition of which, or the treatment of which this thing is specifically designed for use in a particular way.
Yes. My lord...
Sorry, way, not spelled W-A-T-Y.
Yes.
Sorry, spelled W-A-Y, but...
So, my lord, yes, as a matter of logic, I see the difficulty I have standing before you as an advocate now is if I say, yes, that sounds right, I don't want to be said that on behalf of my clients I'm conceding for some later.
I won't hold you to it. I'm just trying to
but my lord,
understand what this is supposed to apply to.
My lord, yes, that on its face, subject to issues of clarity, that would seem to be what's covered by that, and it doesn't. It's not. Your lordship's questions don't engage with my submissions on designation, but in
literally
terms of
trying
the
to
scope
understand.
My lord, yes.
Cooking milk.
Cooking milk. Yes, I mean the function, the purpose of the milk.
Well, its intended use of.
Yes, freezing milk, if it's particularly formulated so as to freeze it. Who knows? My lord,
Yeah.
quite
Okay,
possible.
right.
But I'm on the basis that I'm representing Dairy UK. I don't want to be hypothetically, possibly, I would say, my lord. I don't want to be binding them at some later date. Then, two, for the purposes of this part, again for this part, milk products means products derived exclusively from milk, on the understanding that substances necessary for their manufacture may be added, provided that those substances are not used for the purpose of replacing, in whole or in part, any milk constituent. So that would be, if there is some additive, a preservative or something that goes in, or indeed something that is added in order to produce a milk product. I don't know, something that curdles it. That would be permissible. And then the following shall be overleaf. The following shall be reserved exclusively for milk products. So these are terms that can only be used for milk products. And then again, the following names, not designations, following names used at all stages of marketing: whey, cream, butter, buttermilk, so on and so forth, including the delicious sounding anhydrous milk fat. but these various definitions, and then B, names within the meaning of Article 5 and Article 17 of Regulation EU, so those ones that we have looked at. So we've had milk and we've had milk products, and then 3, and this is an important point, the term milk and designations, and the designations used for milk products may also be used, so that's milk term and these matters that are referred to above, may also be used in association with a word or words to designate composite products subject to certain conditions. And those conditions are, of which no part takes or is intended to take the place of any milk constituents, and of which milk or a milk product is an essential part, either in terms of quantity or for the characterization of that product. So you can use, let's just focus on milk because it's referred to as a term, you can use the term milk for a composite product in association with another word. So how can you use milk with another word that's not in one of the ones defined, the terms defined above? It can be used in association with a word to designate a composite product, which has to be a product of which milk or a milk product is an essential part, and it can't have a component which is intended to take the place of milk. So that's to protect the purity of the milk.
Can you give us an example of that?
So what you could do for that is, and this one, strawberry yogurt is what was referred to below. So here you have a composite product, yogurt, or chocolate milk. And my Lord Justice Arnold's coffee milk, if that's what you were, if you were having coffee flavoured milk, you're putting coffee in your milk.
Okay.
Rather
It wasn't a
than
good
being
example.
coffee. Well, it was seductive. It sounded like a good example, but then off down a rabbit hole we go. So that's
Yeah.
so. But point 3 is governing milk as part of a compound phrase, and your lordships may see where I'm coming from in terms of post-milk generation here, which is part of a compound designation as well. And we say whatever post-milk generation is, the oat milk to which it's to be applied in the oat yogurts or replacements, they don't satisfy the requirements of 3. Not least because oat milk is intended to be a replacement for milk. And indeed the various oat products to which post-milk generation is intended to be there. So we say the regulation contemplates the use of milk as part of a composite term in this way, and says you can't do it except in these specific circumstances. And then point 4, as regards milk, the animal species from which milk originates shall be stated if it is not bovine. So fair enough, you've got to say it's goat or some other. Then point 5, this is the key provision for your lordships today. The designations referred to in points 1, 2 and 3 may not be used for any product other than those referred to in that point. So point 3 in particular, we say, so the designations that are referred to. So in point 1 it's milk. In point 2 it's these milk product names, various other matters. And then point 3 is milk or milk products combined with something else. So we say designation in point 3, contemplate that, may not be used for any product other than those referred to in that point. So if I'm right that post-milk generation is a designation within the scope of 3, which would be milk combined with some other term, because post-milk generation does not satisfy the goods for which it's been registered, do not in any sense satisfy the requirements of 3, because they're all non-milk goods, that use would be precluded by 0.5 on its face. So the only thing that can save my learned friend on that, we get onto the proviso, is to say that designation excludes a trademark. And just pausing there, there's no basis. If the ethos, as it is, of this regulation is to protect the consumer and to foster competition and clearly define what is milk and what is not milk, what is a milk product or a composite product and not a milk product, then to exclude trademarks would make no sense given their prominence in marketing. That doesn't engage with the ethos, the purpose of the legislation, which is to protect the consumer. The exclusion of trademarks in a marketing provision, it makes no sense. So, then the proviso. However, this provision shall not apply to the designation of products, the exact nature of which is clear from traditional usage, and those are the ones, as we'll see from Tofu Town, that have been defined in the Commission.
Well, I don't agree with that reading Tofu Town, but we'll come to that later.
And or when the designations are clearly used to describe a characteristic quality of the product. But pausing there, assuming, step back and assume Tofu Town is it's not as I say it should be interpreted, and so that list doesn't govern. Yes? Then
No. The point is that Tofu Town says that the list
Governs
covers the entirety.
My lord, yes, I see that, and my lord, it may look like I'm looking a gift horse in the mouth when seeing that, but I have been, in order to ensure that milk-free is free for use, there must be a gap within here, and so I wrestling with that where I've landed, and I see the difficulty with Tofu Town because they seem to apply both limbs to that list. Wasn't necessarily what they were thinking.
And neither side is advising us to depart from Tofu Town.
My lord, no. My lord, no.
But you both presumably also agree that milk-free has to fit here, be permitted somewhere.
My lord, yes. My lord, yes. Well, I can't speak from a learned friend,
Well,
but I certainly say that milk-free should. My learned friend says milk-free fits within that second limb of the proviso, and I agree because I can't see where else to put it.
yeah. So
But again, my lords, that's a question of the sense of the legislation as a whole. Designation and exclusion from designation of trade names wouldn't save milk-free. So it's a side issue. The question of whether or not.
Quite, as you say.
But in any event, post-milk generation is certainly not a traditional usage, and we say it does not clearly describe a characteristic quality of a product.
but you say a trademark can be a designation.
My lord, I say a trademark is a designation.
Yes, okay.
Always a designation. It's
Yeah,
just
all
a
right.
particularly powerful and useful designation.
Right. And so, but you would say, that, for example, if somebody had trademarked something including milk-free, then that would be permissible under the second limb. The one I had in mind, curiously, and I don't know whether this is right, but I can't believe it's not butter.
Yes. I can't believe it's not. So if a trademark included milk-free, that's one of it. It'd been interesting because milk-free is inherently not distinctive.
Yeah, but I can't. Something like I can't believe it's not butter. I mean, I don't know whether that was trademarked, but
It is.
It certainly was, because there was a case about it.
right, and so that would be okay.
Well, my lord,
You'd say
again,
it's a designation.
My lord, I'd say I can't believe it's not butter as a whole is a designation. I would say
But
it includes butter, and so it is on the face of point 5 verboten. Can't have that. Yeah? But if I were acting for I can't believe it's not butter, I would say it clearly is used to designate a characteristic quality of the product. If I were less fettered by trying to make it all fit together, I might say, well, it all has to be on the list, and it's not on the list that the Commission has had. But that's not the position I'm adopting before you. So that would be, if I, without knowledge of the facts of that case, had to say how I thought it wound up on the register.
You can assume I don't have knowledge of the facts of that case.
But that seems like a possible explanation, though it's a question of who takes the objection, it might be
Yes, but this may be one of those situations where the position has changed post the decision in Tofu Town, because of course, as we all know, prior to June 2017, producers like Oatly described their products as oat milk and were thought to be complying with the law in doing so, but the Court of Justice said otherwise. And I can't believe it's not butter might be in the same position, we don't know.
I don't, to be sure. Though, it's in a better position.
And that's why they went over to oat drink. So whoever had that registration might have changed its brand name for that reason.
I would, yes. Which is a bit stepping back. I can't believe it's not butter. It's not a bad brand. If one's not thinking about a designation, it's if you were the marketing team, you'd be quite cheesed off.
Well, indeed, that was the whole reasoning in that case, because the argument was it's a slogan, and it doesn't function as a trademark. And the answer was yes, it does.
So that's where we get to 1.5. So we say post-milk generation, not within the proviso, is within the first limb, is prohibited. And then 0.6, this is the provision that Malone and Friend, I think, relied on below. It does something different. Whereas 0.5 concerns the use of designations that fall within points 1, 2, or 3, and which products they can be used in relation to. 0.6 is not to do either with specific products or, and it expressly excludes, it's not tied into specific designations. So in respect of a product other than those described in 1, 2, and 3, so not milk, not milk product, not a composite product, but falls within 3, no label, commercial document or publicity material of any form of advertising, as defined in so and so, may be used which claims, implies or suggests that the product is a dairy product. So you can't, this is a broader point saying, without necessarily using the term milk or any of these other terms that are in there, you can't claim that it's a dairy product if it's not one of those 3 products under 1, 2 and 3. So it's really doing a different job. But the second part of 6 provides an exclusion to that broader point, which seems to engage if one has to put milk or one of those products, whey, cream, butter, so in the list of ingredients, which is instructive in the present dispute. So, however, in respect of a product which contains milk or milk products, but isn't within 1, 2, or 3, the designation milk, or the designations referred to in the second subparagraph of points 2 of this part, may be used only to describe the basic raw materials and to list the ingredients in accordance with those directives. So you can use those matters within the list of ingredients. So there, if you just picture what's going on there, the designation milk or the designations referred to are then being used as a list of ingredients. They're not being used as the name of the product. They're being used as something within the ingredients, and that's expressly allowed. But again, this is inconsistent, we say, with designation only meaning the generic name of the product. And then, just for completeness, part 4, which is on the next page, is milk for human consumption. This is a part that addresses milk itself, and it was referred to. It contains a reference to sales description that is to be used for these products. So, insofar as I think on appeal, the learned judge was concerned that there was no reference to sales description within part 3, and I think he read some significance into that, but it is in part 4, it does define sales description that is to be used for the milk, but there's no more to it than that. So, that brings us to the Tofu Tang case. Which is at tab 8 of the bundles. And we can take some of this relatively quickly because we've gone through at some length the materials which the court referred to there. Here the CJU considers how the Article 78.2 restriction affects the use of designations such as tofu butter and veggie cheese. And indeed, at one point, one of the designations concerned is soya 2 tofu butter.
Yeah. And soya 2 is and was then a registered EU trademark.
My lord, yes, and well, certainly we say soya 2 is a brand name, and it's considered within the designations. This judgment did not engage directly with the question of whether a trademark could be a designation. That wasn't a question before it. But we say there is nothing within it that is inconsistent with our construction, which is that a trademark does constitute a designation, and indeed there are things that are inconsistent with my learned friend's position, not least that reference to soya 2 tofu butter. Because if it's a trademark, it excludes it from designation, then why are they referring to it as a designation? So, paragraph 3 sets out the legal context. It refers to the provisions we've already looked at, recital 76, 64 and 76, paragraph 3. And then the court again sets out under paragraph 5, article
yeah, well, we've looked at all of that.
We've seen all of that, my lord, yes. And then there's an important point in paragraph 7. So here, the CJU refer to Annex 7 to the regulation that we've looked at, entitled Definitions, Designations and Sale Descriptions of Products, and it refers to the definition of sales description as the name of the food. So that was in their mind. And then, having gone through all of the provisions we've just looked at under paragraph 8, at paragraph 9 on page 176, this is a point that weighed in the judge's mind. What's said is the provisions of Annex 7, Part 3 to the regulation reproduce, without making substantive changes, the provisions which were set out previously in Annex 12 to Council Regulation, the previous version, established. So what they then call a single CMO regulation, which reproduce, without making substantive changes, the provisions of the earlier version. So, my lord, what is said there is that Part 3 reproduces, so the matter that is in Part 3 of Annex 7 that we've looked at, which doesn't include that definition, the definition comes at the start of Annex 7, reproduce, without making substantive changes, the provisions which were set out in Annex 12. And that's absolutely correct. But Annex 12 does have that definition of sales descriptions, and the judge on the appeal seems to have viewed this reference to Part 3 of Annex 7 reproducing the earlier Annex 12 as somehow importing the definition of designation as being what is now called the sales description. And that was an error, and it seems to have then coloured his approach. But it's absolutely plain that the CJU didn't think it reproduced that, not least because, as we've seen at paragraph 7, they've set out what the definition of sales description is. One can see how it arose in that what's said is that Part 3 reproduces provisions that are in Annex 12, and that's true. The provisions that are in Part 3 do reproduce Annex 12, they just don't reproduce all of Annex 12, which includes the definition section that came before it. And then there's references to, again, we've looked at, and Article 71 of the regulation about names of foods and the relevant German proceedings. And then the dispute is set out at paragraph 15. And as we see, the question at 15 is whether, so VSW, a German association whose responsibilities include combating unfair competition. Tofu Town is a company which produces and distributes vegetarian vegan foodstuffs. It promotes and distributes, among others, pure plant-based products under the designations soya tube tofu, butter, plant cheese, veggie cheese, cream, and other similar designations. So we say there, insofar as the CJU were thinking about it, and I'm not saying they were at all, but they do not consider the inclusion of a trademark, such as soya tube, as precluding something from being a designation. And then the question was whether the addition of terms to describe the plant origin of materials, such as butter or cream, rendered them was permissible. And the answer the court came to is that no, it's not. That you have to fall within the particular scope of Article 78. And we see that consideration of the questions, set out in 19, can Article 78.2 of regulation be interpreted as meaning that the definitions, designations and sales descriptions set out in Annex 7 need not satisfy the relevant requirements of the Annex if the relevant definitions, designations and sales descriptions are expanded upon by clarifying or descriptive additions such as tofu butter. So they're saying, can we add something if it's clear? And then further specific questions about point 1 and point 2 and the names that are allowed to be used there. And the court then considered the three questions together, it often does, and addresses the schema of Article 78.2 and Annex 7. And well, if I can just ask you to read down to 24 rather than going through it orally. So the upshot, if I may, on the first one is that the designations that are being used, to refer to milk with the various other plant-based matters, are not permitted under point 1 because they're not, it's a purely plant-based product rather than being milk. And then similarly, at 25 onwards, they adopt the same approach and analyse the position in relation to milk products and express the view that is not allowed. Check if I got that. And then at 31, the court turned its reference to the third point, to the composite product point and composite designation point. So 31, as the possible relevance in order to determine the lawfulness of the use of the term milk or designations reserved exclusively for milk products by regulation 1308/2013 to designate a purely plant-based product, of the addition of clarifying or descriptive terms indicating the plant-based origin of that product concerned, such as soya or tofu mentioned by the referring court, it must be observed that Annex 7, Part 3, Point 3 to that regulation provides that the term milk and the designations used for milk products may also be used in association with a word or words to designate composite products of which no part takes or is intended to take the place of any milk constituent, and of which milk or a milk product is an essential part either in terms of quantity or for characterisation of the product. So that's the scope of point 3 as I address your lordships. However, 32, these conditions are not met by purely plant-based products, since such products do not contain milk or milk products. That's exactly the case here. Point 3 cannot therefore be used as a basis in order to designate purely plant-based products for the lawful use of the term milk or designations reserved exclusively for milk products associated with clarifying or descriptive terms indicating the plant-based origin of the product concerned. So the upshot of those three, addressing point 1, 2 and 3 in Tofu Town, is that my learned friend's mark, unless it is excluded from the definition of designation, cannot, or does not fall within the permissive provisions of those points 1, 2 and 3, and in particular, in that it is a composite use of milk plus other terms, post-milk generation, it's excluded from point 3. So, at paragraph 33, furthermore, although according to Annex 7, Part 3.5, first subparagraph, the regulation, the names referred to in points 1, 2 and 3 of Part 3 cannot be used for any other products than those which are set out therein, the second subparagraph of point 5 provides that the first subparagraph does not apply to the designation of products, the exact nature of which is clear from traditional usage, and or when the designations are clearly used to describe the characteristic quality of the product. So that's the proviso. And then at 34, the list of products referred to by the latter provision has, by virtue of Article 12b(1) of the regulation, now in substance Article 91, being laid down in Annex 1 to Decision 2010-791, therefore only the products set out in that annex fall within the exception laid down in the second paragraph.
So that's it.
That's it.
To get within the proviso, you have to be on the list.
My lord, on its face, yes, and it is perhaps peculiar for me to be saying as the appellant that I think it doesn't exclude.
But the Court of Justice has told us unequivocally that that is the case.
Well, can I question whether it is unequivocal? Because what they've said is the list of products. Now, if we look at the second subparagraph, as in fact we can see it from 33, there are two things. One is the designation of products, the exact nature of which is clear. And then the second thing is where the designations are clearly used to describe a characteristic quality of the product. So the first bit is product, the nature of which. The second is a characteristic of the product. Now, what the Commission decision actually does is list the products. It doesn't list characteristics. It lists the products. So I read the Commission decision as, and indeed I would, at least at the moment, think it's possible to read 34 as referring only to the list of products. That's what they say. It's not dealing with, the decision is not dealing with characteristics, a list of the characteristics. And then that's pretty clear if you look at the Commission decision, because the Commission decision lists products. You know, it lists coconut milk, cream crackers, salad cream, ice cream, jelly cream, table cream. It doesn't list characteristics, and so isn't that what the
My Lord,
Court of Justice is saying in 34?
well, my Lord, so what the Court of Justice is, I mean, Lord, what the Court of Justice is doing in 34 is essentially reciting what the Commission decision says, and the Commission decision itself, which is behind tab 1, there are two relevant parts of it. So, first of all,
It lists products.
it says list of the products referred to in the second subparagraph of point 3.1 of Annex 12. And so on. So that is, it's on its face, the Annex, a list of products. And Article 1 that says the products corresponding on the territory of the Union to the products referred to in the second paragraph of point 3.1 are listed in Annex 1. So again, that's
you
again.
have to look at the recitals, which confirm what the Court of Justice says, because recital 2 of the decision refers, by way of exception, to the principle being not applicable to the description of the product's exact nature of which is known because of traditional use, and or when the designations are clearly used to describe the characteristic quality of the product. Then in recital 3, the member states must notify to the Commission indicative lists of the products which they deem to meet within their own territories the criteria for the above mentioned exception.
Well, yes.
Okay, but I will play devil's advocate just for a little bit on this, because it's puzzling to me, because they the whole ethos of this surely is that there is, in each particular member state of the EU, there are, I'll try and use the word correctly, there are products, the exact nature of which is clear from traditional usage. And it's each member state saying, in our jurisdiction, if you use the designation, if you designate a product, everybody knows what its nature is. You know, salad cream. It's not, you know, even within the recitals, it's only listing the products. It's not listing the characteristics, and I do wonder whether I'm not going to repeat myself, but I wonder whether in fact it's reading too much into this decision or 34 to suggest that this decision was ever intended to relate to the second limb of the second subparagraph of point 5.
My Lord,
And that would be an explanation, that would be a way of squaring the circle and reconciling the decision in Tofu Town with milk-free.
my Lord, against it, my Lord, the recitals, and my Lord, Lord Justice Arnold was absolutely right. Recital 2 was where I was going next. The recital address both limbs of that, and indeed, they in recital 3 refers to the criteria that are to be applied. So that the whole thrust of it, well, contrary to what, I just to be clear, my submission are that I don't need the second limb because it's not clearly described in the present case. And I, as a matter of logic, I might look at it and say, well, there's milk-free should fall within the second limb. But the CJU have referred to this, and their decision does little more than recite what's in the recital and the product. So it uses the term, so it just shoves it further up the line. But looking at it, it is the difficulty I have, and to a degree I'm bidding against myself, but the difficulty I have is the decision addresses both limbs, and although it's referring to products, it may well be that the decision is that these products you can then use. It is possible that even with such products and using the terms that are set out, for example, cream soda or cream crackers, one might do that in a way that nonetheless did not clearly designate.
But sorry, recital 2 just simply sets out the terms of the exception. It's just saying this is the exception. The exception has 2 limbs. One is a product, the exact nature of which is known because of its traditional use. And the other one is designations are clearly used to describe a characteristic quality. But if you ask, what does this Commission decision do? It only is, I think the argument is, it's actually only a submission by the member states of the list of products which meet the criteria. So they're only submitting. They don't anywhere submit that in our jurisdiction a designation would be used to describe a characteristic quality of the product. All they're doing is describing the product.
Well, that's not necessarily true, for example, when you look at cream in the list, because cream is a characteristic quality.
I think.
And what you're allowed to do is examples are given of products, including cream sherry and milk sherry.
At the moment, I think all the things listed are products rather than characteristics.
They are listed products. They are listed products, but they are names.
But it says
products.
used in the description of a spirituous beverage. The product is the spirituous beverage.
So Article 1, the products corresponding on the character union to the products referred to in the second paragraph are listed.
Yeah, but cream, as used in the description of a spirituous beverage, it's a product. For example, and the example cream sherry, milk sherry. I mean, that's a product. Nobody is suggesting that it's clear from that a characteristic quality of the product is, for example, that sherry has cream in it.
My lord, no. But what is sorry that for cream sherry or milk sherry, through traditional usage, it's understood that it means that it's a particular kind of sherry that isn't to do with it's both. It's and or, my lord. So this is the problem with the recital, and the problem with the is these are 2 limbs that can both be in place at the same time because it's and or. And so listing a series of products, it may well be that the Commission has said, well, this is it, and on the face of it, this is what the CJU said, is these are the products, the names that are used for products, that fall under both of these limbs. Because and or would mean they aren't. But my lord, my instinct, if I were writing this legislation, I'm not. My instinct would be to say that milk-free must have a role, and where it would fall would be in the second limb. But the difficulty I have, and why I find myself floundering somewhat, is that you're faced with a very clear decision of the CJU that recites the Commission decision. And there is certainly an interpretation of it which is entirely consistent, that it covers in both limbs, which is what the CJU have said it covers. But it might be that the ball just went past them and they weren't thinking about it, because they're thinking about the... So it's not that helps.
Well, exactly, but there's 2 different questions. Question 1 is what did they say, which seems to me to be utterly unambiguous. The second question is whether it's right.
My lord, yes.
And it may not be. But since we're not being invited to depart from it, question 2 we can fortunately duck.
My lord, it would be... It's extremely convenient for my case, if I thought I needed it to be able to duck the question, because we say it precludes the proviso applying, because post-milk generation is not on the list. But
can I just ask? I mean,
Oh,
perhaps
yes.
I'm not misunderstanding this, but the only reason you're going through this sort of torture is because you're trying to accommodate
Enjoy it.
milk-free.
my lord,
Hardship.
yes. And milk-free isn't before
In
you.
this case, we're talking about what you say is a description which is not in any event characteristic, used to describe a characteristic quality of the product.
My lord, yes, though my learned friend says that it is. He says post-milk generation
Yes.
describes a characteristic. And I
But
look
you
forward
disagree
to
with
him
that?
answering. Well, I disagree.
Yes,
I
obviously.
disagree, and it's an argument I'm having because by admitting the possibility of it, I have to argue with it. But there is he can be precluded from being able to run the argument at all in the light of what's said by the CJEU.
Yes.
The difficulty I have, and I'm not asking to depart from that, I'm not instructed to ask you to depart from that, the difficulty I have, perhaps as an advocate, on this is I can see the force of this point, but your lordship's absolutely right.
Why
It's
couldn't
not
it be
relevant.
that milk-free is actually precluded? Because it doesn't fall within the list and it falls foul of the other points. Because there's a perfectly good substitute, for example, lactose-free or something like that.
Oh, yes. Or you could say, why would you want to tell someone necessarily?
Well,
Or-
what you might want to tell someone is it's milk-free because those who are lactose intolerant, for example.
Or perhaps it could be put in the. It might fall. Well, I'm not sure now because it's not excluded by the ingredients. At the risk of appearing cowardly at this stage, having stood and fought both sides, and perhaps to a degree, in a way that cuts against my client's interests in certain way, my primary position is it doesn't matter in this case. And if it had mattered, then I would be engaging and saying that you as a court should depart from the decision of CJU on this point. But to do that would be against my client's interests, and also, even if they hadn't said what they said, we say we're still all right because post-milk generation isn't clear, and that's the view. Well, it appears to be the view that the hearing officer took, though she didn't explain herself in any detail. She just said it's not within that. It's not within the proviso.
Right.
So, my lord,
Let's move on.
Let's move on. So, back to Tofu Town. Take this relatively swiftly. The decision, so we've looked at 34. And then faced with, in 36 to 39, there's a suggestion that matters had moved on. And at 39, the court recognised that in order to satisfy demonstrated need from involving consumer demand, technical progress, or need for product innovation, the Commission is empowered to adopt delegated acts regarding amendments, derogations, or exceptions relating to the definitions and sales names. So it's saying if this were an important point, it'd be addressed. Hasn't been done here. And then at 40, we get to the conclusion. They hold the term milk and the designations reserved exclusively for milk products cannot be lawfully used to designate a purely plant-based product unless that product appears on the list. And the addition of descriptions or explanations indicating the plant origin of the product at issue, such as those at issue in the main proceedings, does not affect that prohibition. We're just pausing there. That is, if it were possible to clearly, to express matters so clearly, to refer to the characteristic of the product, so milk-free, so on and so forth, then it might be that 40 would have been expressed in a different way. So it does appear that they're consistently addressing this closed list. And then,
Yeah, well, and it makes complete sense as soon as you realise that item 1 on the list is coconut milk,
yes,
which of course is plant-based.
yes, exactly. And then at 43, addressing Tofu Town's submissions that this is all contrary to principle of equal treatment and generally unfair, the court addresses recitals 64 and 76 and says the aim in improving the economic conditions for the production and marketing as well as the quality of such products, the application of such standards is therefore in the interest of producers, traders and consumers to protect consumers and to maintain conditions for allowing competition. Those provisions, insofar as they provide that only the products which comply with the requirements they lay down can be designated by the term milk, and designations reserved exclusively for milk products, even if those designations are expanded upon by explanations or descriptions, post-milk generation, such as those at issue in the main proceedings, contribute to the attainment of those objectives. So the point is, limiting it in this way is in accordance with the consumer protection and the competition stimulating aims of the regulation. And at 44, in the absence of such limits, those designations would not enable products with the particular characteristics that relate to the natural composition of animal milk to be identified with certainty, which would be contrary to the protection of consumers because of the likelihood of confusion which would be created. That would be contrary to the objective of improving the economic conditions for the production and marketing and the quality of milk and milk products. Pausing there, that doesn't require a likelihood of confusion to be engendered by this. It's a prohibition to avoid that possibility arising at all. It's a provision of clarity.
Well,
And then again, so 48.
and the last sentence is pretty clear that this is about protecting milk producers.
My Lord, allowing milk producers to compete in the way that they'd like to. And so then, again, 48, they address again the use of milk designations reserved exclusively for milk products required, and say this is, again, in accordance with proportionality, and then the dispositive is at 52, having regard to all the foregoing considerations. The answer to questions referred is that Article 78.2 and Annex 7, Part 3 to the regulation must be interpreted as precluding the term milk and the designations reserved by that regulation exclusively for milk products being used to designate a purely plant-based product in marketing or advertising, even if those terms are expanded upon by clarifying the prescriptive terms indicating the plant origin of the product use at issue, unless that product is listed in Annex 1. So, unless my learned friend has a trademark exemption, as it were, so designation somehow is not within the term, within the ambit of the term designation, Tofu Town does fail on its face. And we say that there is no basis for reading it more broadly than that, and for reading an exclusion in relation to brand names or trademarks into designation. And the judge's finding that that is what should be done was based on an error and his erroneous readings of the definition of designation in an earlier version of the regulation. So with that in mind, I can turn quite briefly to the decisions below and just show where the judge fell into error. If your lordships are familiar with the hearing officer's decision, I don't propose to take you through it. I think we've referred to the important parts. So the decision is at tab 5. So doing this quite quickly, sets out the relevant provisions. Page 33, paragraph 7, addresses the hearing officer's decision and records paragraph 8 the hearing officer's finding that the average consumer would view the mark as an ironic way of saying its goods have moved on from conventional milk and are for the consumers of a post-milk generation, i.e. those who no longer consume dairy milk. But again, the hearing officer held that that was not inconsistent with her earlier decision to say that point 5 and the proviso did not apply. Then,
Well, we can pick it up at 34, can't we? Because that's when he gets to his actual
that's the heart of
analysis.
it. So, 34.
And he goes wrong straight away, doesn't he? Because he says that it prohibits the use of designations in point 3 for any product. But of course, the whole context of this is Article 78.2, which is for the marketing of any product.
Yes. My lord, yes. But you can see it's about marketing, and it would be perverse, we say, to exclude trademarks from provisions, at least if not done expressly, from provisions concerning marketing. At 35, his definitions we don't cavil with. Point 1 is concerned with milk, point 2 is milk products, point 3 is composite products. But then at 36, where he addresses designation, 36.1, he immediately goes wrong. He says the term designation is not specifically defined in the regulation. That's correct, albeit Part 3 of Annex 7 reproduces without substantive change, Article 12 of the Single CMO regulation, the latter defining designation as the name used at all stages of marketing, as that phrase also appears in point 2a of Part 3 of Annex 7 to the regulation. And that's a reference to footnote, designating exclusively milk products, the following names used at all stages of marketing. Now, Part 3 of Annex 7 does reproduce without substantive change.
Yeah, well, you went over that before.
Yeah. So, but he's gone awry by importing the definition. Then at 2, again, at this point, things really seem to have been going wrong. Point 1 designates exclusively milk. This is a truly unhelpful use of the term designation. In that
it's a definition.
It's a definition
Yeah.
of the term. And then again, point 2. So the point of is designated. He does not. He also doesn't. Well, he's just tied himself into a knot. At point 3, again, he uses designates milk products as the names of products, and is using designate when he's defined. And then point 3 designates as composite products milk or designations used for milk products. So again, designate is defining. Used for milk products, used in association with a word or words where no part of that composite product is to take any part of any milk constituent, and of which milk or a milk product is an essential part in terms of quantity or for characterization of the product, e.g. strawberry yogurt. So, my lords, we accept that strawberry yogurt is a reasonable summary of what point 3 is intended to allow, or chocolate milk, or some such. But his characterization of it, we say, is confused. What the point stipulates is that the term milk and designations used for milk products may be used with other terms in certain limited conditions. It doesn't designate as composite products milk or designations used for composite products. I mean, it's you sort of got into a bit of a mess on Little Roman 4. And having gone through all of that, it's all tied in to his view that a designation means the name under which a product is sold at all stages of marketing, which is not the relevant definition. So, at 37, he says, as explained in Tofatan at 44, the designations contemplated by points 1 to 3 are concerned to enable those products with the particular characteristics related to the natural composition of animal milk to be identified with certainty. We say that's correct. For dairy products, that is achieved through the use of certain terms and names constituting the exclusive designations for milk and milk products, sometimes in association with other words, and the prohibition in point 5 against their use for any other product. Again, we agree, he's right there. In short, Part 3 ensures that only those products that are truly dairy products are marketed and sold as such. Again, that's the point. In that sense, the appellant is correct to say that the term designation connotes a generic description of the product. Now, that final point is not quite right. So, the term designation encompasses a generic description of the product, but it doesn't connote, it's not limited to that. And by viewing it as being limited in that way, it then colours his conclusions, his analysis in 38, which again starts okay, but then rapidly goes wrong, we say. Accordingly, were the appellant to market and sell in the UK an oat-based drink as oat milk, that designation would fall foul of the regulation in the same way as plant cheese did in Tofatan. Correct. Milk and cheese both being protected designations for dairy products, points 1 and 2, their use as designations for the plant-based products they describe would not be permitted. Correct. However, it would be open to the appellant to name one of its products as oat drink, since the name would not implicate the protected designations for dairy products. Correct. The use of the mark, so this is a mark that includes the term milk, in conjunction with that oat drink product, would also be permissible, since although the former contains the word milk, the mark would not be used to market and sell the latter as milk. But that's not the point of the prohibition. It's not to use the mark to market and sell, the word milk to market and sell anything, whether it's milk or not. Not being descriptive of a particular product, rather than, as the hearing officer found, indicative of the appellant's products more generally as being those who no longer consume dairy milk. So, I have to say I find great difficulty. I find the final sentence difficult to grapple with. He appears to be saying that it's not objectionable, his post-milk generation, or any mark, let's call it, that include the term milk, would not be objectionable if used as a mark, because it wouldn't be descriptive, because there's no milk in it. Because it's not designating or suggesting that there is milk in there, that somehow means it's out with the scope of a designation. Now, that might work as an interpretation if designation is defined as excluding trademarks, but otherwise it's completely nonsensical, in my submission. Because there is no requirement in point 5 that a mark be used, a designation not be used descriptively. If it's not being used descriptively, it's just don't use the designation for a product. If you use the designations in 1, 2, or 3 in relation to a product that doesn't fall within them, then that's not allowed unless you're within the proviso. And then his point of paragraph 39 reveals absolutely clearly where he's got it wrong. As such, I also agree with the appellant that the hearing officer construed the prohibition of point 5 too widely so as to encompass the mark. Where she appears to have fallen into error is to assume that the use of the term milk in the marketing of products or food products at least constitutes, without more, the use of the designation for milk within the meaning of regulation. Yes, that is what she was doing, and yes, she was correct to do so, we say. However, it is the use of the term milk for products to identify them as being milk, not merely its use in marketing, that constitutes their designation as such. There's no basis for that at all in the regulation. In this case, the mark is registered for a variety of goods in different classes, and although it may well have been used in their marketing, well, it has to be if it's a mark, it does not purport to market them as any particular product, let alone milk. Well, if used in accordance with the goods and services for which the goods for which it's been applied, then it is to be used in non-milk products. Since the mark does not designate those goods as milk, point 5 is not engaged, and no question of the proviso to point 5 arises. So well, at that point, he's just got it wrong. He's tied himself in knots in relation to the meaning of designation and has read into the regulation some requirement that the milk must, apparently must be intended to inform the consumer that there is milk within the product. Paragraph 40, he's right about point 6. And then 41, I am reinforced in my view by the fact that the term complained of, milk, appears in a trademark which by its nature is distinctive of, indicates a unique trade source and is not descriptive of the goods for which it's registered. My lord, in my submission, that's completely irrelevant. In this regard, Article 5.2 of Directive 2013 and 17.4 of Regulation 1169/2011 provide it's not possible to replace the name of a foodstuff with a trademark, name protected by intellectual property, or a brand name. Pausing there, they do, but that's in the context of the mandatory provisions for labelling. So you can't take off milk from your product and replace it with Cravendale. You still have to say milk. The respondent says this is only relevant to sale descriptions within the meaning of Article 17 of the regulation.
78.
78 of the regulation, sorry. But Part 3 of Annex 7 expressly refers at point 2b to those other provisions of EU law as sources of the names of foodstuffs or food, the actual use of which also gives rise to their designation under the regulation. My lord, that simply doesn't follow. The definition where those are found is relating to sales description, as was submitted below, and insofar as that brings in these names as part of the general reference to designations, it's only because designations is broader than sales descriptions. And then he agrees. As such, I agree with the appellant that such designations are mutually exclusive from the mark. Oh, my lord, he was wrong, but that, to be fair, he may have been led astray by his initial consideration of the definition of designation as being the sales name, and once he got that in his head, he just went south all the way. So, my lord, for those reasons, we say that the appeal should succeed. You'll ought to have had my submission in part of the longer debate that we've had in the context of what the list means and whether it's closed. You've got my submissions in relation to my learned friend's point on whether the proviso applies. If it's wrong, we say no, it doesn't, either because it's excluded by the list, or sorry, his mark is not on the list, or in any event because it doesn't clearly designate. Then finally, the second ground of appeal, which in my submission we shouldn't need, but if it is the case that designation excludes a trade mark and only applies to something that is said to be an indication of a generic indication of what's in a product, then when considering the mark, one would have to consider notional fair use across the breadth of the specification. The mark is a word mark, post-milk generation. Post could be small, milk could be bigger, generation could be smaller. It is when looking at that, the average consumer might well see the word milk as designating something about the product and not being part of it. And as such, that would then also bring it within the prohibition under Article 78.2. My lords, unless I can assist you further, unless perhaps it's to do with whether the list is closed and in terms of the Commission regulation, in which case I've addressed you at some length, but unless I can assist you further, those are my submissions.
Thank you. Mr. Eden.
My lords, I'd like to start off by trying to neutralise the point that somewhere along the lines the judge below misdirected himself with respect to a confusion over the terms sales descriptions and designations. In my submission, he did no such thing. But in order to show the strength of my point, I need to actually take you to the new regulation and the old regulation. So, starting with the old regulation, we need to look at the structure of it in order to see how it's being carried through to the new regulation. And so you'll find in your authorities bundle behind tab 2 the old regulation, that's 1234 2007. And if we start at page 28 of the bundle, looking at Article 114, paragraph 1, foodstuffs intended for human consumption may be marketed as milk and milk products only if they comply with the definitions and designations laid down in Article 12. And then paragraph 2, without prejudice to the exemptions provided for in community law, it then talks about milk falling within code CN 0401. This is important, you'll see why in a moment. We turn the page, we get...
Just pausing there, this is all about marketing standards, whereas when we get onto the subsequent regulation, we have provisions about marketing standards, and then we have Article 78, which is explicitly in addition to marketing standards.
Yes. I was going to address that, if I may, when I come to 78.
All right.
But I'll try not to forget it, but I'm sure if I do, my Lord will remind me.
Sorry, I've lost your page. I've lost the page reference.
I'm sorry, my Lord. I was on page 28 looking at Article 114.
Yeah.
That's the substantive article in the old regulation, 1234 of 2007. And paragraph 1 brings in the terms definition and designation. And I also drew your attention to paragraph 2, which is to do with milk sold or falling within code 0401. If you turn the page of the bundle to page 29 of the bundle, we have Annex 12 to that regulation. And this is set out in the following format. With Roman 1, we have definitions. Roman 2, you have use of the term milk, and that has 4 parts. And Roman 3, use of the designations in respect of competing products, that has 2 parts. And what we'll see in the new regulation is that...
But just before we get on to the new regulation, am I correct in understanding that when we look at Part 2 of Annex 12, what we find is that point 1 corresponds to point 1 in the new one, point 2 corresponds to point 2 in the new one, point 3 corresponds to point 3 in the new one, point 4 corresponds to point 4 in the new one, but there is nothing that corresponds to point 5, at any rate in Part 2.
Correct, my Lord.
Nor indeed point 6.
But if you go to Roman 3, those are the bits that correspond to points 5 and 6 in the new regulation. It's just been divided up differently, my Lord.
Right.
So therefore, in the new regulation, what you find is in Old Roman 2 and Old Roman 3, parts 1 to 4 and parts 1 to 2 respectively, reproduced in what is now, in the new regulation, Annex 7, Part 3, points 1 to 6. That's the translation code, so to speak, the table between the old and the new. Now there are some differences in the wording, but that reflect basically the changes in the other directives and regulations that has occurred over the period of time. But, my lords, what you do not find in the new regulation is anything that corresponds to Roman 1 of the old regulation under Annex 12. And a lot was based upon that. That definition, Roman 1b, designation means the name used at all stages of marketing. That wording is not copied over. And then much was made of the fact that sales descriptions turns up in the new regulation. My submission, that's actually just all misunderstanding the way in which the new has been formed from the old. Now, concentrating a little bit of the heading of Annex 12, you can see that it says definitions and designations in respect of milk and milk products referred to in Article 1141. That's what I referred you to earlier. And my lords, I have handed up to you, which you should find in your desk, Annex 13.
Right.
So this follows on directly from page 30 of the bundle. You can see that by looking at the top right hand. It's the next page, basically. It follows on from page 106, page 107 and 108. So this is Annex 13 to the old regulation. And you can see marketed in milk for human consumption referred to in Article 1142, which I mentioned. And then you see this is also divided into Roman 1, Roman 2, Roman 3, and so forth. And in Roman 2, little 2, it talks about the sales descriptions to be used for those products. Now, to dovetail this all together, because this is the way in which you see that what I'm going to say is that the old has been reproduced in the new, if you turn back, please, 2 pages to page 29 of your bundle, so I'm now back in Annex 12, and under Roman 2, under use of the term milk, under 1a, it says, for milk treated without altering its composition. My learned friend read that part out. But then it continues, or for milk, the fat content of which is standardized under Article 1142 in conjunction with Annex 13. So you see how Annex 13 is referred to in Annex 12. Now,
But that's for standardised fat content.
yes, yes. But the point being is, my lord, is that it's in Annex 13 that the term sales description turns up. Now, sales description is not used in Article 114, but it comes into Article 114 through the second paragraph, because the second paragraph takes you eventually through to Annex 13.
All right, but can you point us to any definition of sales description in this regulation or the annexes?
Yes, my lord. Can I answer that question in a moment? Because otherwise I'm going to be chopping and changing. I was just going to draw your attention to no, that will do. Okay. If we then go to the relevant regulation, which you'll find in your authorities bundle behind tab 6.
No. My question was about this one,
Oh, sorry, misunderstood.
the 2007 regulation.
Yes.
My question is there a definition? You've drawn to our attention that Annex 13,
Yes.
but not Annex 12,
Yes.
uses the term sales descriptions.
Yes.
And my question was, is that term defined in this regulation, that's to say the 2007 regulation?
No, that's it's not defined. The point is, it turns up there.
But you accept there's no definition.
Yes.
Right, thank you.
But the reason why it's relevant that it turns up there is because the way in which the wording of the new regulation is formulated, it picks up upon the sales definition, sorry, the sales description.
All right, but do you dispute that we find, so far as definitions are concerned, the following? The 2007 regulation contains a definition of designation, but no definition of sales description. By contrast, when we come on to the 2013 regulation, we find there is a definition of sales description, but not a definition of designation.
Yes, but my lord, that doesn't fuss me for the following reason. Because I say that the term designation has been copied over in the same context as it was used in this 2007 regulation, and therefore its meaning is the same. So in the 2007 regulation, in Annex 12, the term designation is defined as the name used at all stages of the marketing. And that's important, at all stages of the marketing. That's the definition of designations in 2007.
Fine, but that definition is not in the 2013.
I accept that there is not the equivalent repeating of those words. But my point is that the structure of the new regulation is such that the meaning cannot have been changed. And that is why I'm taking your attention to Annex 12 and 13 of the old regulation to show how the terms definition, designations and sales descriptions turns up. And you'll see that from the old regulation in Article 114, the terms...
Well, if the legislature had intended the term designation to retain the same meaning, it would have reproduced the same definition, wouldn't it?
No, my lord, I don't accept that for the following reason. Because the whole structure has been copied over. The only thing that's actually just been omitted is Roman 1 of Annex 12.
Well, not just that, they've inserted a new definition which wasn't in the old one.
Not for definition, not for designation.
No, but for sales description.
Yes, but that is different from what we're talking about. This case focuses upon the word designations, not sales descriptions. But sales descriptions is actually used in the same way in the new regulation as it was used in the old regulation. That's the point. Much was made by my learned friend that under the new regulation, Article 78, there's this trio of terms: definition, designations and sales descriptions. And my point is those three words are given the same meaning as they were used in the old regulation. It's just that Article 1141 only used two of those terms expressly. So if you go to the new regulation, behind tab 6, what one has here is Article 78. So the new regulation is much wider than the old regulation, deals with many other different products. Article 78 is the relevant one for our purposes on page 141. This is headed Definitions, Designations and Sales Descriptions for Certain Sectors and Products. And the point being here is that this is where you get the the three words or the three phrases, definitions, designations and sales descriptions, provided for in Annex 7. Then we go to Annex 7.
Well, just before you move on, I'm still struggling to understand how you can say that these two regulations have the same meaning. Apart from anything else, Article 114 is concerned just with milk and milk products, whereas Article 78 extends to beef and veal, poultry meat, eggs, and so on.
Yes. But, my lord, the point is that the old regulation, Annex 12, has basically been copied over verbatim, say for various updating bits, into Part 3 of Annex 7 of the new regulation. There's not substantive rewriting at all. In fact, there's no rewriting of the substantive parts. So if the functional parts...
So can I understand the structure of your submission? Do I understand you to be saying that we construe the word designation in Article 78 by reference to Annex 7, and we construe Annex 7 by reference to Article 114 and Annex 12 of the predecessor regulation, even though the definitions have changed?
No, my lord. It was the last part with which I disagree. I say that because of the old regulation, Article 114 and Annexes 12 and 13 have been substantively reproduced in the new regulation, Article 78 and Parts 3 and 4 of Annex 7, that there can be no change in the meaning to the word designation. Because when you look at where the word designation is being used in a functional sense, in the new regulation, it is used in exactly the same way in the old regulation. Now, there might not be an actual express definition of the word designation in the new regulation, but its meaning cannot have changed because the operative parts have not changed. If you wanted to change its meaning, you would have needed to have defined it differently. You can't imply a change just when there's been no change in the operative parts. Sorry, my lectern was wobbling. I was just trying to fix it so it doesn't annoy everybody. So, on the new regulation, in 78 we now have these three different phrases. Those are mirrored in Annex 7, which starts on page 143. This is where, at the beginning, my Lord Justice Arnold, you get the definition of sales description. But what is interesting here, from my point of view, is it says the name under which a foodstuff is sold. And so that's in contradistinction to the definition that occurred of designations in the old regulation, because it's limited to one particular point in the commercialization of the product. But they both refer to the name of something. Under the old regulation, the term designation was the name being used at any point in the marketing. Under the new regulation, it is the name when that foodstuff is sold. And then in both cases, we say that you need to look at Directive 2000 number 13 EC and the other regulation 1167 of 2011, the Article 5 and Article 17. Now in both of those cases, it talks about the name of the product, And in both of those cases, the name cannot be an intellectual property right, such as a trademark. And so Article 1 talks about Article 5.1 talks about the name. Article 5.2, which I can take you to, is on page. Oops, if I can just find it. Article 5 can be found on page 33, and Article 5.2, no trademark, brand name or fancy name may be substituted for the name under which the product is sold. And Article 17.4 is to similar force. The name of the food shall not be replaced with the name protected as intellectual property, brand name or fancy name. And what's interesting about the first directive to which you took you to, which was 2000 and number 13, is that the beginning part of Article 5 talks about the name under which a foodstuff is sold. So that clearly looks like it's referring to a sales description. But with respect to Regulation 1169 of 2011, Article 17 does not seem to have such a limitation on the point of sale. The name of the food should be its legal name. But the point here is that the name cannot be a trademark. Now, going back to the current regulation, I've started off on page 143, which is the commencement of Annex 7. And this is where the definition of sales description was, and that's cross-referred to that Article 5 and Article 17. And then within Annex 7, the two relevant parts are Part 3, which starts on page 151, and Part 4, I'm terribly sorry, yes, Part 4, which starts on page 153. And Part 3 is the subject matter of this appeal, milk and milk products. Part 4 is milk that falls under code 0401. And so that is the bit that had its genesis in Annex 13 of the old regulation. And that is where, again, it's been all reproduced. Basically, there are changes, but that's basically because of updating due to the fact that this is a newer regulation. But you can still see in Roman 2, number 2, the sales description is a reference there. And with respect to Part 3, milk and milk products, this is where the terms definitions and designations are found. So because of the way in which the new regulation has been restructured, you go from the old regulation that had in Article 1141 the terms definitions and designations, and only by implication sales descriptions in 1142. In the new regulation, in Article 78, because it's now bringing everything together, it refers to definitions, designations, and sales descriptions all together. So there's been no change in the meaning of those various terms. They're just in a different place and differently organised. My lords, that's probably a good point to stop if you wish.
Yes, certainly. So, this appeal was originally listed for half a day. I don't criticise counsel on either side for the fact that we are going to go over because there's some dense material to get through. But how much longer do you think you will go?
I'll probably speak for about an hour, but then there'll be questions on top of that. Yes, I'm being defensive. I'm sorry, my lords.
All right.
We'll finish today. I mean,
Yes, well, we have
have to finish today. Yes, I know, but I mean, there should be no doubt about that, my lords.
All right, is it,
2 o'clock.